Look, my preference conflicts with what I read as a reality. My preference actually is for us to have Article 1182 equally repeated under 117. That's my preference, i.e., the speaker must at all points in time be involved in the process. I think it helps because it allows for not only institutional autonomy, but it allows for some checks against the executive. Because we should not forget that all these things happening, the police are part of the executive. And for a lot of the difficulties we have now, there's some reality we are not talking about. And that reality is a historical one. The police suffers from a historical deficit of trust. There is a deficit of trust which both parties in government are blamable for. And usually when they're in opposition, they see the problem magnified. When they're in government, they do the same things. And now when parties are in government, they also don't see the problem. When they go into opposition, suddenly they see the problem. So we have a situation in which there's a deficit of trust in terms of institutional manipulation of the police. And because of the institutional manipulation of the police, there's a sense in which anytime the police makes a move, particularly against the other organ, there's a perception that somehow the executive is behind this. So that institutional deficit in terms of police manipulation and the deficit of trust is what undermines this. So I would prefer that we have a situation in which 1182 is actually repeated under 117. But if you look at this from a purely constructive, in other words, the construction of statutes and the interpretation of laws, the principle is you do not assume that a lawmaker made a mistake.
And Prof Abotsi has been referring to two particular provisions of the Constitution. I just want to read them to you so that we continue. Now, the first provision is Article 117. It says, civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. We've put that in a slide. We'll put it on the television so that you see it. So that whilst a member is attending to, on his way to, attending at, or returning from any proceedings of Parliament, it says civil or criminal processes coming from outside of Parliament shall not be served on or executed in relation to that member, the Speaker, or the clerk. And the heading of that provision is immunity from service of process and arrest. He also referred to Article 118 and Clause 2 of that. Article 118 is entitled Immunity from Witness Summons. Immunity from Witness Summons. Neither the Speaker nor a member of nor the clerk to Parliament shall be compelled while attending to Parliament to appear as a witness in any court or place out of Parliament. 2, the certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament.
Thank you, Samson, for that. So I think the provision speaks for itself. And for me, the problem with interpreting 1182 alongside 117 is to expand the immunity of members of Parliament. And the reason I find that a bit problematic is because the whole point of police powers of arrest is that the police exercises an administrative discretion when they decide whom to arrest. The power of arrest is a discretionary one, which avails the police once they think that certain elements of an offense are made out and they decide to arrest you and activate the judicial process, so to speak. So once the police decide to do that, the idea that they would have to go through a third person to make a decision in terms of whether or not a person, the arrest process can be completed, in my opinion, it distorts the power of arrest. I think the reason 117 is the way it is, without bringing the Speaker under 117, is to enable that discretionary authority to be exercised. And when it is exercised, and the person has to go to court, and the person is being processed, the additional responsibility of a person who is arrested and who's acting pursuant to the power of arrest, i.e., attending to court, acting as a witness, at that stage, the processes cannot be served on that person unless and until the Speaker is brought into the fray. And the reason that is to ensure that as far as the judicial component is concerned, the speaker indicates whether or not a person's parliamentary functions will be interfered with and whether or not a person is attending to the functions of his office as a member of parliament. And as I indicated earlier, we are dealing with a situation of trust. Until we deal with that, this problem will continue. If there's trust in the institutional autonomy of the police, very often when they exercise these powers, there'll be no problem. Indeed, in the UK, where we seem to have copied this, the powers of the police are limited. Oh, sorry, the immunity of the members of parliament is very limited. Limited in the sense of a member of parliament can be arrested at any time for criminal offenses, mainstream criminal offenses, and the immunity is restricted to breaches of State Secrets Act, breaches of slanderous offenses. If the person commits a slanderous offense, for example, that there's an immunity. Yes, exactly. So defamation in parliament or slander, and then contempt of court. Where the person is guilty of contempt of court, slanderous offenses, or breaches of State Secrets Act, those ones the member of parliament has immunity. But otherwise, for the commission of regular offenses, there's no immunity. And the reason this is important is because of the rule of law. We must have equality of law, equality of all persons.